can't even imagine. But you must enjoy it.
Yep.
Outside and make sure the screen is working. Other printouts?
I just printed them
So
out
is-
from Eric's email,
Oh,
Is this the
okay.
same thing that the council wants?
I didn't bring.
but I can,
Do you want me
I
to?
can't answer that.
Want me to go grab a copy then? If it's not too much trouble.
I cannot answer
I
that.
just thought you had, would probably be copies.
Well, does it legitimize?
Yeah, I made a
Retail
couple. I
sales?
have,
I don't think it does it?
It depends how he's registered.
Well, it says here, it's the
The new 13, the old?
medical cannabis
the
dispensary,
red
which
one.
I don't,
The new red one.
the state changes the nomenclature all the time,
Yeah.
which is
The game.
3/4 of the problem. But that's on purpose.
Big money.
So I thought he could be a medical cannabis dispensary. But in practice, what he was doing was,
That's it.
He's acting the
in practice, he was being a retail.
Right.
He could be a caregiver, but not a caregiver retail store or a dispensary.
He can be a
That's in
dispensary?
the past, he could have been, or he was.
He was a caregiver,
Right.
but not caregiver retail store.
Correct.
But what about?
And that's what he was shooting for, that's what the council was shooting for.
For a caregiver retail store or a dispensary.
Why are they the same thing, a dispensary?
Well, as a-
Caregiver dispensary?
No, like a medical dispensary, from what I'm told
Okay.
and understand, would be like a corporation would own a dispensary, but like an individual would have a caregiver retail store. But essentially, they would do kind of the same things. And they're just for medical. And I mean, I think we had talked about that before.
Thanks, Eric. Sorry for the.
No, I'm good.
Sorry, I'm just trying to coordinate with my doctor. He's on his way from work. So when it was passed, the city council recognized that it still needs to be worked into the codes and ordinances, and they made their motion that we needed to work on this. We sent it, because, I mean, Eric and I don't have the time to do this, so we sent it to North Star Planning. We finally got their work back, which I think is what Eric's saying. Yeah, to Eric. So I'm looking at you and saying Eric and thinking it wasn't you, but it was
No,
Eric.
it wasn't me.
Sent you what we got from North Star Planning to be able to make the changes. And then Karen read through it and felt like there were some other changes that needed to be made too. Because like I said to the planning board, but also the council, what we have needs to mimic what's in the law. You know, we have to call them by the same things they are called in the law. Because at one time, it was calling it something that's not really recognized as the right verbiage in the actual cannabis law.
In hours, in the,
Hours, was it? Because they were calling it like a retail medical dispensary, but that's like not the actual word.
It doesn't mean anything at the state level.
Correct.
To fall under their
Yeah,
rules.
their definitions of things. So, Maine Medical Use of Cannabis Act. So when you're looking through definitions, and this was something that Karen and I have talked about a couple times since we got this back from North Star Planning, was trying to mimic the language that's in the definition section of this, and, oh gosh. Like, there's a definition for, the problem was, they have a new definition for caregiver retail store, which they didn't have before, and that is what caused all of this issue.
Yeah, but it wasn't just that, it was in the zone that he was in also.
Well, right, because you couldn't have a dispensary in the R3 zone.
Right.
Right.
So forget about all this for a
Mhm.
second. I'm
Mhm.
just being devil's advocate here.
Yeah.
We haven't changed our zone.
Right,
No.
the zone that being operated in wasn't correct.
It wasn't correct for retail,
Right.
like for a dispensary. But we have limited, home rule for where someone could operate as just a caregiver. Not a caregiver retail store, not a dispensary, just a caregiver. Because the state really will not allow us we can't tell someone they can't be a caregiver. In
But wasn't
theory,
but
we're
wasn't a-
supposed to be able to have zoning that would limit things, but in practice, it doesn't really work that way. With caregivers, which are licensed by the state. But because of the change in the rules, put this on, which created the caregiver retail store, that's when this all, because of the addition of that definition, that's what caused all this.
The
Because he
mushroom.
wants to have a retail store, whether it's called a caregiver retail store or a dispensary, it's at the end of the day the same thing, which is meeting that definition.
So this would be a retail store similar to the Presque Isle, what used to be Ben's? They have a retail location in Presque Isle.
Is it medical or is it adult use? Because the Presque Isle, I think, allows
it's
both.
Only medical.
Okay.
I'm assuming that's what he'd like to have for an operation here in Caribou.
Mm-hmm.
You're talking R&R remedies.
Mm-hmm.
Yes.
Richardson Remedies, yeah.
Well, this document says no caregiver retail stores permitted. And no adult use
Right,
cannabis operations permitted.
Because I guess what they decided was that because the city already allowed the nonprofit dispensary, that I guess a smaller step and not as big a leap with changing to caregiver retail store would be to allow a dispensary. Because we already had a nonprofit dispensary in town, which was left over from the old way of doing things on the state level, which was the state had a limited number of dispensary licenses given in the state, one per area and I don't know how they divided up the areas, but our area here in Aroostook County, it had been in Eagle Lake, and then they moved here to Caribou.
So is there a nonprofit dispensary in Caribou?
I honestly don't know if Safe Alternatives has transitioned away from being a nonprofit dispensary, but they always were.
Is that on
Before the
Presque Isle-
passage of this.
On the Presque Isle Road?
Yes.
So
And
is the new name, according to the state, medical cannabis dispensary?
Well, that's what I'm trying to find out.
Instead of nonprofit dispensary?
That's why I'm looking at the definitions, trying
And that's what,
to find for sure what's the right
that's
one,
what
because there's,
Ben changed it to. Did he change it because of the law, or did he change it because of the council?
well, I don't know. I don't know if he changed it because that's what was passed, or if that's what the law is. And that's what I'm trying to look up, but I'm not doing a good job of that.
The other change in the law was to allow, previously dispensaries could only be nonprofit. And they changed the law back a year or two ago to allow them to be for-profit and gave them instructions to transition if they wish to a profit. So now you have two categories of dispensaries, profit and nonprofit. And I believe his location down in Presque Isle is still caregiver retail.
I think so too, because that was
Because
one of
they
the
allow
issues,
that.
yeah,
We don't.
yeah,
They
right.
allowed it, and so.
Who, Presque Isle, you mean?
Mhm.
Yeah.
So that location was seamless for him to just continue doing it. But what's also true is that he was operating as a retail establishment under a caregiver license, which isn't allowed. And so the state came down and told him to cease and desist, you cannot do that. And basically, shut him down and said, you must not operate a retail store. And so that, in combination with the new law changes, is
Well-
an issue.
That's what brought him to the council.
Because he was stuck. He had to do something. And he did not want to close down his retail establishment.
Well,
And we said all, some of us said all along, well, you can continue to operate under your current license as a caregiver. Nobody's getting in the way of that. But he didn't want to do that. He wanted to continue to have his hours, have a sign, and have, retail store.
So the council attempted to allow him to do that.
The council agreed that they wanted to find a way to allow him to continue operating.
And what was the title they put in the document?
The title of what?
Was it caregiver retail or nonprofit?
Dispensary, medical dispensary.
Just medical or retail medical dispensary?
It's registered dispensary. I don't think there is a retail dispensary.
So if you're a registered dispensary, you can sell to the public.
Under the definition, yeah, under the definition of registered dispensary, so, and I gotta,
Oh, I'm sorry. Registered medical cannabis dispensary.
I don't think that's the state law. I mean, I can't find that, I can only find registered dispensary.
Because in the multiple iterations of this,
Mhm.
new chapter 13,
Mhm.
they had to go back and change it to be correct.
Mm-hmm, I'm gonna pull
Maybe,
that
maybe
up.
they didn't, maybe they didn't. I don't know.
So yeah, so on the first page, that's what it says. Registered medical cannabis dispensary is what's proposed. So that must be Ben trying to align the council's document with the state current language.
Okay, I'm looking at the form.
Ben's North,
Ben Smith from North Star Planning.
North Star
'Cause that's who
Planning.
we worked with to try to help us with the wordsmithing. Karen just sent me an email about that it is the registered medical cannabis dispensary on the form. Do I not? I have a caregiver form. I don't seem to have the dispensary
Eric, do you
form.
know what the colors mean?
So I know the red, I guess the red on the first page of the chapter 7 where it says site design, they had initially put site plan, so I think anything in red is what my comments reflected. And then I guess I don't really know the difference between the purple and the blue.
So this document, chapter 7, that's Caribou's document? That's being edited, modified?
Yeah,
And so red means Caribou's document, strike through this language, add this language. So what's the difference between that and blue? And down here, purple?
I think generally it was changing the existing language versus adding new language is probably the biggest difference in working with North Star.
But I think what he's asking, who made those changes? What are the colors mean?
Right.
I don't think we know.
probably would have to go back to the emails, because I think it probably on the email it will say who did what.
I didn't know if it was Caribou's document and one color came from the council's document and the other color comes from the state law changing the names and it looks like it's a compilation of
It is.
documents. And I think colors might reflect that, but I don't know that.
Well, it looks to me that whatever's in black is the original chapter 7, as is currently And anything you see colored are proposed changes.
Yeah, but why are they multiple colors?
That I don't know.
Yeah.
I sent-
Just to highlight the confusion of the cannabis law,
They do it well.
or it's to make it festive.
I'm guessing that all the edits that change the name to registered medical cannabis.
So a registered medical cannabis dispensary means that somebody can go there with a card or work with the proprietor to get a card. And once you have a card that says cannabis will help your medical condition, now you can purchase
That's great.
profit or non-profit, doesn't matter, I don't
The
know.
card has to come from a doctor, doesn't it?
Yeah,
Doctor?
yeah,
They figured.
yeah, but they have them on the phone, they call them up, they call them up and,
An 800 number and $39.
But what
Yeah, just forget
what I
about that
was gonna
part
say
of
is
it.
I think those, I'm guessing the changes in blue were made by Karen.
Well, so I have her,
Because she was very
note
keen
that
on
she
making
sent
sure
me.
that the name was correct.
Oh, you know what it is? Clicking through this Word document, it's just Ben versus Ben's assistant planner.
Okay.
So Ben and Anna Rosa are the two at North Star.
oh,
So that's the red and the,
And the purple is their former planner, Sam Peaks.
oh, so it's three people, but it doesn't mean anything, other than their changes from different inputs.
Sorry.
yeah,
Okay,
but Karen's,
Karen's a color too?
no, she sent me an email, and it said, the term registered medical cannabis dispensary used every time to be consistent. Also, the term registered cannabis cultivation facility should be used, because we have marijuana in our thing
Right,
instead of
right, right.
cannabis, yeah.
right, because it could be two distinct places, right?
Yeah.
One for growing and one for
So,
selling with a
yeah.
car.
So Dan, so he was a medical dispensary, right?
No, never was.
What was he?
He was a caregiver.
And, okay, explain what a caregiver is.
And Penny, correct me if I'm wrong.
Yeah, no, I'm listening.
A caregiver was intended to be a private consultant who was authorized to deal with the marijuana on a one-on-one basis with his clients. And it was intended to be a kind of an in-home, private, not a business where you have traffic coming in all hours of day and night. Just more of a personal one-on-one consultation.
Were
That's
they
what a
limited to
caregiver-
6 clients?
Pardon?
Were they limited to 6 clients?
At
think
one
initially they
time,
were.
yeah, they had it initially.
But there was no medical qualification in that
Yes.
relationship?
No, that is medical. You had to have a medical card.
But weren't they limited to so many plants per
Yes.
client, was the other part of it?
And a recent law changed that to expand it. I say recent, it could be 4 years ago. I'm just trying to think what the sequence of things happened. When they first started, like Penny said, the dispensaries were limited to the state. And then 8 years later, they changed it to be unlimited, across the state. So, but that's not relevant to your question. The caregiver was, now I think they are limited in the number of plans. I don't think they're limited on the number of clients.
Haven't they deleted the word marijuana?
Yes,
Yeah.
it's now
So it's
cannabis.
Cannabis.
Mhm.
So there's still such a thing as a retail cannabis?
I don't know, I don't.
Yeah, because there's caregiver retail stores, but I think they used to, adult use had been called, I think, retail, right? Like it was
I believe
medical
so.
and then retail, but then they decided retail was gonna be called adult use.
The recreational?
Yeah, recreational retail, yeah, and then it's now adult use. I don't know.
There's not much of a distinction anymore. Retail, what does that even mean? It's exchange of funds for product.
Mhm.
You know, what do you even call that? They're de-emphasizing the word retail. But it still exists in the caregiver retail.
Mm-hmm.
So I see in here, it says the city clerk is authorized to issue 2 licenses for only 2 registered dispensary licenses. That's what it's saying in,
That's what it says,
Mhm.
and that's, in my opinion, that's totally wrong, because the city clerk doesn't have the authority to unilaterally issue permits at her desk. I mean, this is supposed to come to the planning board, public hearing before a permit, so the planning board should be approving that permit before it's issued.
We're in chapter 13, right, Eric?
yeah, chapter 13.
And the chapter 13 circumvents that whole process to allow somebody to come right into the court and say, can I have a permit, please? And there's still a lot of things I think that need to be fixed in the chapter 13. I'm convinced that this is going to happen, the council wants it to happen, regardless of the court challenge. I mean, eventually it's going to happen, so we are going to have to reconcile all of these things. But I think I'm relying on the planning board to inject some sense into this, because some of the things that are laid out in chapter 13 aren't consistent with 7, and there are unintended consequences to those things, and I don't think it's the way we want to go.
So the way that it had worked previously, every year, Safe Alternatives, which was our only dispensary, had an inspection by the police chief, the fire chief, and the code enforcement officer. And then that renewal application came to the city council with a public hearing. And that's how it was in the chapter. And that removes that in here too. It's just simply like you're characterizing. You come in and you submit your paperwork. If your paperwork is complete, you're issued your license. There is not an additional public hearing at the council level for a renewal. That was something that was taken out also.
What do they do for a liquor license?
So a new liquor license needs to come to the council for a public hearing, but renewals, when the city clerk gets an application for renewal of a liquor license, same thing. The fire chief, the police chief, and the code enforcement officer have to review the application. When the 3 of them have approved of the application, the city clerk sends the city manager, because that's been delegated to the city manager to do renewals. So she sends that to me. It's all an online process now. I just did one today, as a matter of fact, for Northern Maine Brewing Company. No, Evergreen Lanes. So I go in, and then they have different attachments. I have to go and open them up, and then I have to go in and say if I approve the renewal or whatever.
So it's not that the applicant appears
No.
where the public has a chance to vent.
Only that initial application. But the
during-
renewals are not.
During the year, like a neighbor has found that there are issues at the establishment that the police have not been involved in, that would at least give that neighbor a chance to bring it to the attention.
Yeah, that was changed maybe 10 years ago or something, because it used to be even renewals came to
Yeah.
the city council, but the problem with that is, scheduling a public hearing, and then sometimes, I know this is gonna shock everyone, but sometimes people don't plan ahead, and they're like, oh gee, my license is expiring, I guess I better do this, and they present themselves here, and somehow it's become our problem that they have procrastinated. I mean, we ran into that with when the new owners took over the Jade Palace. Like, they wanted to say it was all our fault that they weren't getting their liquor license, and they had a lag between, but we process things as soon as we have the paperwork, but we have to abide by our ordinances that say that we need a public hearing, and here's how many days it has to be scheduled, and also abide by state things. So, I mean, we do what we can, but we're not miracle workers when people procrastinate. And I think there was a lot of that going on maybe 10 or 15 years ago. I mean, I worked here, but I didn't work in the manager's office at the time. And they decided to just delegate renewals for the manager to do. And again, you have 4 sets of eyes on there. The city clerk is going over it, the fire chief, the police chief, and any of the liquor licenses. If they want a special amusement permit, if they're going to do something different or have an expansion of premises because they're going to have cornhole or something outside, that's a separate application too. And again, it's looked at by the clerk, the fire chief, the police chief, the code officer, and then I have to go in and approve.
Are there only
it.
4 places in Caribou that have liquor licenses?
Oh gosh, there must be more. It seems like all the time. Like so, like the VFW has a liquor license. American Legion, Bucks Bar, Sports Inn.
I don't think the VFW does.
I think they do.
Par's got one.
They just
Par and
awarded-
Grill.
They just awarded it last month. Remember?
Yeah, they upgraded theirs. I think they had something and then they upgraded it so that they could do something else.
Last month or the month
Yeah,
before,
we
they
had- we-
brought an application
yeah.
for a liquor license and we approved it.
Right, but I think they had one and they like upgraded it to something different. Or maybe they didn't. Maybe I'm thinking of the American Legion. I don't know. There's
Yeah.
quite a few anyway.
But they have one now.
But they have one now, yeah. Sports Inn, Evergreen Lanes,
Jade Sizzle and Slice.
Sizzle and Slice, that's right.
Hotel.
Yeah, the hotel. There's quite a few.
Okay, back to the issue.
Yeah, well, I was just answering his question. His
Yep.
question was about liquor licenses.
I need help from my fellow board members. Let's go back a year before all this stuff hit the fan. As a board member, I think, I'll speak for me, but we felt comfortable in the position we were in to not allow marijuana to get out of hand, because we had 2 dispensaries and they were grandfathered and the waters were calm. My question is, under this revised chapter 13, we are highlighting that we are only allowing 2, and we mention it several times. We're limited to 2, we're limited to 2. So, if Dave and Frank want to open a little dispensary next to his fruit stand, you're discriminating against Frank and I by having this limitation. I don't believe, I think I could win if I took you to court.
Well, you wouldn't be taking me to court. You'd be taking the city of Caribou to court.
Okay.
But
That's
I mean,
unfair
we-
business practice.
I don't know. We're told that municipalities can put limits. I mean, advertising limits, is that kind of advertising that you're not allowing some people to do something? I mean, maybe. You know, whereas before we weren't really advertising how many we were allowing. We just had it in there that we could have the nonprofit dispensary. We didn't change it when the state laws changed and it went from marijuana to cannabis. We didn't update the ordinance. We didn't,
Well, that's-
you know what I'm saying? Like,
I know.
we just let it alone, to your point. Like,
Right.
a year ago, we were just kind of letting it be and not,
In my
But-
estimation, that was insignificant. You know, that wasn't
Yeah.
a big to-do because we
Mhm.
had it wrong verbiage.
but we had it right at the time. It's just
Yeah. I think
state law
state-
changed.
I think state law says you can limit limit how many.
Yeah, I mean, that's what we've been told, but I also don't know what court cases there have been around.
Well,
I
maybe
can't
it hasn't
tell
been
you
challenged,
that.
but-
Yeah, exactly.
I haven't seen that in the state law. I've only heard that from the proponents of Richard's remedies that are coming in, saying, oh, you can do this, you can do this, in OCP.
Yeah, I think OCP had said that you could,
They said that, but
I can't
where are
remember.
their interests? You know, so I agree with Dave, and I think I mentioned that during the debate. You know, we are unfairly limited, you know, unfair business practices and opening ourselves up to a challenge on that.
And it's one thing to say, we'll only issue 2 licenses, rather than say, we're moving in this direction to not allow it, but the 2 existing businesses will have, in here it says 60 days to get their license, and then it becomes a non-conforming, grandfathered non-conforming use, which, I guess I don't know the exact timeframe in our zoning, but usually it's 6 months or a year of non-operative business, that non-conforming use ceases, so then it kind of goes to the non-conforming use piece. So
That would only be for safe alternatives, because they're in RC2,
Mhm.
and we turned everything on its head and said they're not allowed in RC2, but are allowed in RC3.
Mm.
It's a mess.
We might be 12 months. Or at one time, we were 12 months.
The other thing that was suggested, I think, by Rich and not acted upon is you need to have a fair and impartial process for awarding those permits. You have to advertise it out, you give everybody the opportunity to submit, and not shoehorn a favored business into one of those licenses, and that's exactly what happened. So that's another basis for somebody to come in and challenge. How come you got it? I never even knew this was happening. I want a dispensary. How come you awarded it to this guy? We never knew anything about it, and we never given the opportunity.
Is it too much to ask Ben and his North Star Planning Group if we could redact where we mention limiting to 2, only 2, and go with grandfathered?
Well, grandfathered isn't really a word. Like, I've always wanted to get a sign that says your grandfather doesn't work here. But as Eric said, it's a previously existing non-conforming use.
Okay, that's even better. I was trying to keep it simple.
Mhm.
Would that be acceptable? I'm just asking.
And I don't know the answer. I'm not an attorney. I mean, I feel a lot of times that the council should have a city manager who's an attorney. I think it would probably be better for the town to have an attorney for the city manager, but
You feel like going to school for 4 more years?
I do not, and I don't even think it's just 4 if you're going to be an attorney. But, so I'm not an attorney, but when we talk about a year ago and things that were allowed under our ordinance, the only business that was operating under this ordinance was Safe Alternatives, who was a nonprofit dispensary. Again, left over from when they had so many around the state, and the state kind of told you, yes, you're going to have one in this area, and it was here. As Councilor Bagley has said, Mr. Richardson was operating as a caregiver. The state felt that he was doing more as a caregiver than what their licensing allowed him to do, in the way that the sales and to his patients were being handled out of his caregiver office. So before August of 2023, there wasn't really a definition for a caregiver office, but now there is a definition for a caregiver retail store. So it is my understanding that the way things were run at that location were more like a caregiver retail store, which is, as Counselor Bagley said, why the state told him he needed to cease operations the way he was conducting them as a caregiver at his location. And that is why he approached the city about trying to change our ordinance so that he could maintain the level of service to his clients that he was giving them before the new definition made what he was doing not in conformance with our ordinance.
And he was not a previously operating, non-conforming. He wasn't, because he was a caregiver and not a dispensary. And so if he wrote that into the law, he was not a dispensary, so he would not be allowed to continue operations. He was not a dispensary at the time. We've always said that as a caregiver, he's free to continue operating. And it's his decision to not do that, or not want to do that. So he wants to be something else. So it burdens on him to figure that out within the state law. But he decided to say, well, I'll go for a dispensary, to expand to make basically what I want to do align with the law.
And he has a compliant business 10 miles down the road.
And 42 miles up the road. I think that's how far Madawaska is from Caribou.
So Safe Alternatives is a dispensary,
Correct,
and he wants to be a dispensary.
correct.
So how is Safe Alternatives a dispensary if we didn't have the process?
We did, we had it for nonprofit dispensaries.
but
From back,
he-
right.
But he wants to be a for-profit dispensary? Mr. Richardson?
I believe so. I mean, and, yes, it's my understanding.
In the R3.
In the R3, that's the other issue, is the way our ordinance was, they were allowed in the RC2 zone with planning board approval.
So how did Safe Alternatives become a dispensary? Through the state, not through us?
Well, they are licensed through the state, but they have to operate within a community that allows them to operate. So, I mean, Steve could tell you better because he would have been the code officer when this was passed.
They came from Fort Kent, or Eagle Lake, I guess.
Eagle Lake.
So they were in operation at the northern extreme of the county, and I think their goal was to be more centrally located. That's how they got to Caribou. So,
But they came and got an application and got approved and,
Well, the planning board had this language in place before they came here, though. And it's my recollection, but again, Steve can correct me if I'm misremembering, because I didn't work in code enforcement, but I worked for the city in assessing at the time. And it seemed like because of the state and the state's rules, it was almost like a preemptive move to be able to say, okay, because the state was deciding where you were having these dispensaries. You know, they said you need to have one in this zone, which was like Aroostook County. And what my recollection is that it was preemptive to say, okay, well, if the state says we have to have it in Caribou, we want to control where it's going to be located, and we don't want it so many feet from a church. We want it to be in a RC2 zone. And so they passed this ordinance before Safe Alternatives came. Safe Alternatives came and had to work within that framework. So they had to find a place to set up shop that was in the RC2, and they were able to find one. And they did the paperwork in accordance to the ordinance that was in effect at the time, and moved their operations, as Steve said, from Eagle Lake to Caribou.
I think initially we had drafted our ordinance in-house, Mike Hagan and myself. And we had verbiage to limit their proximity to schools, places of worship, I want to say playgrounds. We may have even limited their location to a certain distance from existing daycares. And the attempt there was that not knowing, it was all new to the state. And the state hadn't done what they probably should have done to provide information to the municipalities. So we went ahead and drafted a caribou ordinance. And then thereafter, the state came out with new definitions and terminology of the type of dispensaries.
Yeah.
And I do remember doing the initial inspections and permitting for out on Route 1. And very, very low impact was their business plan was, you know, a client, not even one after another. You know, it was like maybe 6 clients per day would visit the building. And we had them do things, security systems, and I mean, and they were good to work with. And when Darrell came, I think he came after I left. But I have been out there, being that I was still doing the plumbing permits, and somebody had put in an unpermitted septic system. So I was out there for that, which gave me an insight to the operation. And it seemed like he was running as anybody with a medical card came into the office, they could then buy whatever amount of marijuana, or cannabis, I should say. So to me, it looked like a retail type of operation. But not being part of the municipal code office,
Right. Well,
none of my business.
but also none of our business even in the municipal code office, because they are licensed by the state.
Yeah.
Like the municipality doesn't license caregivers. We can't limit the number of caregivers. In theory, you can, you know, have some control over the operation or location, but it doesn't actually work like that in practice, because when you can't limit them and people can really grow cannabis anywhere for their own consumption or for the consumption of people in their household, you know, it's,
Isn't it true that we didn't, until recently, we didn't even know who we had here? for caregivers?
that is correct.
And after, maybe 2 years ago?
Yeah,
the
it's
state
about the same
finally
time,
released that
2023.
information to us, and we discovered we had like 8, 12, something like that. We have like 8
Don't
or
remember,
12
yeah.
caregivers.
Oh.
Caribou.
Yes, for a long time, really, so working in assessing, we tried to petition the state to get a list of caregivers so that we could tax any equipment that they used in their business. I mean, we found that Mr. Richardson was operating because he actually advertised on placemats like at the Jade Palace. So we went out and listed his equipment, but we couldn't get a list from the state of other people that had equipment. There was someone on the Van Buren Road. We also listed his equipment as a caregiver, because in assessing, you want to make sure that you're being equitable and you're picking up everyone who has a similar type of business, whether it's farming or real estate offices, insurance offices, whatever, banks. So we tried to pick up all the caregivers, and so our argument to the state was we should be able to get a list of caregivers so that we can treat them all the same and tax their business personal property. But that was never a good enough argument. But in the same law, the same change of the law in 23, which gave us new definitions, they also changed how that information was managed. So now you can go right on the website. Anyone can, not just me as a municipal official. Anyone can go to their website and pull down who has licenses in your community. So you can find out. But to your point, that was not something that we knew back when I was doing code enforcement and tax assessment, which is when I was personally trying to find out that information. I mean, the other thing about it too, from a public safety standpoint, is, you know, especially people who are extracting oils from the raw materials to make other goods. There was a lot of concern, at least from a public safety and working in code enforcement standpoint, about if we knew that someone had those kind of highly flammable materials in their home, we should let our first responders know, because if they are responding to a fire or, you know, something else there, they should know that there would be highly flammable material at that location. But we could not make that argument to the state either. But they have changed that now. But there's been a lot of change, and you know, every year when MMA will have a little webinar about the changes in the Office of Cannabis Policy, I believe is what they call it now. It's a lot to take in, because they change a lot of this all the time with the statutes and the rules, and even how the information is disseminated to communities.
So if these were redone,
I think so.
not color-coded, and to remove the redactions or the line items, would they be ready to be presented to the council?
I mean, I think that the council would want to see a red line version from the original. And it looks like this from North Star Planning completely implements what was passed in July. That's what this looks like to me. Like,
'Cause
they've
it's-
X'd out in everything that was in the previous ordinance.
Are you
And-
talking about chapter 7 or chapter 13?
13, because what the council didn't touch anything in 7, which was one of the things that, you know, I had said also needed to be changed, because this is where licensing is. Licensing really doesn't belong in chapter 13. Licensing should be over in chapter 7. So the other thing that the planning board could do is, this is what passed, but if the planning board says, okay, our recommendation, because again, like, the way it's supposed to work is, you know, whether it's a citizen or a member of the council that says, I want to introduce an ordinance and I'm sending it to the planning board because it's land use, and I want you to act on this and make a recommendation to the city council. Since you're working on this, I don't think that there is anything wrong with you making recommendations to make this better. Because the whole thing is, this needs to come with a recommendation. So if your recommendation is, okay, this is, because if you listen to the meeting, there are people who voted for this that said, we're going to pass it, but we can always fix it later. Am I quoting that fairly?
Unfortunately.
It was something, I mean, that was in,
Those words were spoken.
right, in July. So, you know, lots happened since July, but I think that the council understands that, like, to your point, they want something passed, and, you know, you agree that they want something passed. But I also feel like they also understand that maybe it doesn't get passed in exactly, maybe there are some things that could be made better. For example, taking the licensing piece out and putting it in chapter 7 where it belongs. That to me is the most obvious one, but to your point about, you know, do you want to say fewer times that there's only 2, or do you want to say, you know, something else about previously existing non-conforming use, you know?
The part that bothers me is in chapter 13, you go to section 5, okay?
Okay.
adult use or adult prohibition on adult cannabis. It's spelled out clearly, no caregiver retail store permitted. Okay, that's black and white. No adult use operations permitted. Okay? But, as Eric said earlier, all we do is change the name to a dispensary. And now everything's okay.
Well, it's okay, so I guess also keep in mind that there are different requirements for the product that is sold as medical cannabis than adult use cannabis. And I don't know, again, I'm not a lawyer and I am not an expert on the finer points of cannabis. But in all the research that I have had to do, you know, since this kind of blew up in, I don't know, April, I think, the adult use is very highly regulated. So when you purchase something from an adult use store, like they can pinpoint the origin of that product, you know, from seed or whatever. The medical cannabis is not as highly regulated of a product. Or it's the exact opposite of that. And then
No, you have that
do
right.
I have it correct? Okay.
Counterintuitive, completely
Okay.
counterintuitive.
Okay. That's because I was thinking, wait, that really makes no sense.
I think they are working on changes to bump up the regimen for testing and regulation of medical.
Okay.
As it stands now.
Okay, so, because when it came out of my mouth, I said, okay, I don't think that's right. So apparently it was right. So it's really not, I mean, words have meaning and we have to be very careful when we are using words to describe activities. But it appears in our main state law, the way, you know, we have medical and we have adult use, we're talking, even though the commodity is cannabis in both cases, there is a big difference not only in the delivery of the product, but the product itself and how it's tracked and produced. And I don't know if that kind of answers your concern that all someone would have to say is that they're a dispensary. Because if they're a dispensary, it's going to be for medical. I don't believe there is a similar language for a dispensary for adult use. Because adult use, I think, would just all be
Retail.
retail. Exactly.
So you're saying medical dispensary has certain kind of cannabis products?
Medical itself is different than adult use.
Right, if you're adult use, there would be a wider range of products.
I think that would not be true, because
No?
I think, because the adult use is more regulated and tested, and like I said, they track like exactly where that came from. But medical can get by with not having those same testing procedures, tracking procedures. So it's two different things. They're both called cannabis, but
Yep.
the way that they're treated under state law is very different.
If we could potentially or possibly transfer definitions out of the Chapter 13 document and land them in the Chapter 7 document, the land use part of it, the cannabis dispensary could go right onto our land use table,
And I-
designating allowed zones. And I think a lot of this could be forgotten, or to do away with much of this, being that we would be putting it into our land use section of the code, but to bring the definitions into the Chapter 7 that explains the difference between adult use and these other terms that we're discussing.
And if I might add, you described the grandfathered verbiage.
Previously existing non-conforming
Right.
use.
Would it be in our interest to also use that verbiage to replace the two registered? I have a problem with that number two. That's just me. Am I right? How do you guys feel about that?
I can see where we would limit the number to two, but it's the process of how we get the two. So if there is a particular year that 4 applicants came forward, filled out their applications, and to treat them equally, are we going to pick 2 out of a hat? How do we come up with the two locations that are gonna comply with the code, the state requirements? How does Caribou come up with the names of the applicants that are gonna get the 2 permits for the year?
Well, you have the ones that are already permitted. They don't become unpermitted. I mean, if one of them
But
stops,
I think they do, though.
so it's a brand-new, fresh look every year?
At the end of their term,
I
their
think-
name can also go into the hat, or whatever the selection.
Do they say, but
I don't like that.
I don't know
I
how
don't
that's
think it
workable at all.
says, yeah.
Because like a car dealership comes in, you buy $1 million worth of cars, and then you're gonna be out of business next year because there's another guy down the street?
That buys it 1.5 million?
Nah, I
Or, or got,
I don't think that's workable.
Renew these licenses or permits. They're under, Steve's right.
It's like saying, you're, just to use an example we have right in the room, I'm gonna build we can only have 2 Christmas tree farms in town.
Yep.
Takes 15 years to grow a Christmas tree. You know what I'm saying? How you,
I don't
you
see
make
that-
that investment though, and how are you gonna?
I see
then
this
you're-
as a controversial discussion.
Oh, it is, there's no doubt.
And
well,
yet-
I think it says in there, first come, first serve.
Yeah, that's what, I was just rereading that, yeah.
If they all renew, though, on the same,
Same minute.
the first,
The clerk gets them, the first one's
January
in, the
1st.
second one's in. If you come through the door 10 minutes later,
So somebody,
we're full.
camps out at 2:01.
Well, I didn't know about the renewal. I would think a renewal's a,
lobstermen do that.
I think the important piece that's in the chapter 13 that's in front of you guys today, on the second page under section 4 to E, in the middle of that second page, it says a licensed registered dispensary in existence at the time of the enactment of this ordinance is considered grandfathered. So we only have the 2 registered dispensaries in town, right?
No, just the one.
Well, it depends. When this was adopted, there was just the one. But under what was adopted, we now have 2. Because
So-
Mr. Richardson submitted his paperwork within the 30 days of enactment of the ordinance.
Can I ask a dumb question here? Was that legal?
Was he under violation within the state at that time?
That would be a question for the state.
Okay, but we have information here that said that he was operating outside of what he was.
I mean, that's what they
So
told, that's what they
okay.
told us, but they didn't, to my knowledge, they didn't revoke his license. Because when I would go online, I believe, and again, like this was this summer, and
So he had a license of good standing as far as the state.
as far as I could ever tell, it was always a good standing, because that's,
But they never produced the documents, right?
They never
Because I think
produced-
that's one
yeah.
thing that we asked for way back was, okay, if there was violations, was it noted? But they didn't, we
they
don't.
did
we don't-
not. And,
I mean, so that's hard, that's hard to,
So the state has issued the dispensary license to Richardson's Remedies?
it is my understanding that they have.
Okay.
So if,
We could check online, though.
depending on how that's viewed, if the city adopts this, and only allows the 2 registered in existence at the adoption of this to apply for those licenses. And then those businesses get those licenses, and if they stop operating for a period of a year, then it becomes non-conforming and the license becomes back up for grabs in a conforming location. That kind of solves, if you get 4, because if there's only 2 in town, you wouldn't be able to get any applications from anybody else but the 2. So that would be effectively limiting it to 2.
That's the way I understand the 2.
And then go to the non-conforming.
You don't
standards
start,
after that.
you don't start at 0. The 2 are in. Nobody can apply until one goes out of business.
Or the ordinances change, or
Right.
the ownership of one of them changes, because it has in here
Well,
something
if
about
you're
ownership
non-conforming,
changes.
then yeah.
Should that be written into the ordinance, that licenses or permits will be automatically renewed?
I'm not sure that it doesn't
I
say.
don't think it says that anywhere. And my understanding is that the city's not under no obligation to renew any license. What if we have trouble with them all year, and they come up for renewal and say, we're done with these guys, we're not going to deal with it, and refuse to renew their license? We have the authority to do that, as far as I'm concerned.
I mean, I think if someone was in violation,
You can
I
revoke their
would
license
think you could revoke it anyway, like if you,
Yeah.
I mean, I'm not reading that right now in here, but,
And there could be language to say, it's not, if that license is revoked, it immediately becomes up for grabs. There could be some concessions made to, considerations made for, the legal process to play out if someone wants to appeal that. So it's not just instantly given to another dispensary that pops up.
yeah, because it does say all registered dispensaries must remain in compliance with applicable building, safety, fire, and health codes, and shall be subject to inspection by city code enforcement officer, fire department, and any other designated municipal authority. And state compliance. They must comply with the Maine medical use of cannabis program statutes and rules, and must remain in good standing with the Maine Office of Cannabis Policy. A registered dispensary will provide the Caribou Code Enforcement Office with proof of an active license on an annual basis. Any violation of this ordinance may result in enforcement actions, including fines, suspension of local authorization, or termination of local operations in accordance with applicable municipal procedures.
So it's been a while now, and I never thought to pull it out. I probably haven't. But Rick Solomon sent a letter with multiple recommendations.
Yep.
And part
That
of it
was
was
in July.
procedural, which coming to the board, even though it's backwards.
Right, but we got everything from Ben Smith. That was kind of what precipitated, everything.
Right. So my question is, do we look at Rick's letter and does this comply with his recommendations? Do you know?
I personally have not looked at that, and I don't think I have a copy in here. I don't think it's been updated since.
Dan, do you remember some other recommendations he had in that letter?
I remember the letter pretty well. He made a number of recommendations on the merits of the proposed ordinance itself.
Right.
Well, he would say things like, well, I wouldn't recommend you do this because there's such and such an impact. So he'd step through, and there were 3 pages of recommendations. And I believe the council made an effort to incorporate at least some of those recommendations into the final version. But my recollection is, when I looked at it at the time that it passed, when I looked at it again, they hadn't captured all of that. And so I think it would be
Yeah, that'd be
worth
great.
a relook, to make sure.
Yeah.
But I think from a planning board perspective, the biggest issue I have is changing the zoning to allow a dispensary in R3. I mean, turn things completely upside down from how we've been, what our philosophy has been for many years.
But we have done non-compliant designations before, without changing zones.
For other things.
Yeah,
Yeah, but you gotta worry about spot zoning.
Yeah.
That was one of the big issues going back to this was you create a non-conforming,
compliant.
essentially spot zoning.
That was one of let me just interject, that was one of the specific recommendations or statements, assertions from Rick. Is what you're doing is spot zoning, and that is not allowed by law.
Right.
He said that in the letter, and you did it anyway.
So I have Rick's letter pulled up here, if that's helpful.
I mean, yeah, that was
So-
one of the issues, regardless of what it was.
Let's talk about the zoning then. What is the rationale not to allow it in R3? What is it about R3 that's makes it a bad place for?
Part of it was too close to other dwellings, is part of my understanding.
It was more of a philosophy as we did not want any establishment like this in residential zones, period. Any of the, you'll see that they're not allowed in any residential zone. That we were gonna limit it only to commercial and specifically RC2. I wasn't here when we went through that, so that happened before me, but in talking with other people,
And what zone is Safe Alternatives in?
they're in RC2. So now they're an existing non-conforming business operating in RC2 when it's not allowed with these changes.
So we have a problem with both of them. Is that what you're saying? As far as zoning?
Well, we made the change to R3 specifically to accommodate Richardson Remedies, which in and of itself was deemed by our attorney to be spot zoning and should not be allowed. It's not legal. And in doing so, and not including RC2, and I don't know why the council didn't just include RC2 and say they'll be allowed in RC2 and R3, just to add R3 as opposed to eliminate it. I think it was just rushed through and people didn't think about it. That's my only guess. But that's easily fixed by just changing it to say RC2 and R3.
Did,
That way-
Dan, did Rick state that allowing Richardson's Remedies to operate in the R3 zone, that was spot zoning?
Yes.
He said.
Because that really isn't spot zoning, it's opening up all of R3 to this particular
Well,
use.
You'll have to read his words. I'm paraphrasing, and I could be putting the incorrect nuance on it. But he mentioned spot zoning.
Oh, is that it there?
Yeah, this is his letter. And I haven't really zoomed in because it gets blurry if it's not super zoomed in.
See, that's about, yeah, it's about caregiver.
Yeah. He says we can limit. See that one, David?
That's just for caregivers.
And,
No, it adds them all.
Oh, I didn't see that.
Want to back up one?
Yeah. Under home rule, to impose regulations upon registered caregivers, caregiver retail stores, registered dispensaries, there you go.
No.
But are
You have
allowed.
to read the first part. Under Maine law, municipalities may not prohibit or limit the number of registered caregivers operating in the municipality, but are allowed
Are allowed,
under
yeah.
our rule to impose regulations upon registered caregivers, caregiver retail stores, registered dispensaries, cannabis testing, and manufacturing
Right.
facilities.
Right, so you can have 8 to 12 caregivers.
You can have, we can't limit the number.
Yeah, we
of
can't limit, so
registered
you're gonna have a
entities.
bunch of them,
Right,
but you can limit
Right.
dispensaries.
dispensaries and retail stores.
Well, if you impose regulations as meaning that you can limit the number, if the state.
Well, it starts out talking about the number, so
No.
it's logical that that's the kind of,
So we can keep our 2.
yeah.
I don't read it that way. I don't read it that way. The first part addresses only caregivers, and it says you can't limit them. But you are allowed to impose regulations on all of them.
Time of day, that kind of stuff.
It doesn't say that you're not allowed to, or you're not allowed to prohibit or limit the number of dispensaries. Otherwise, the first part of the sentence would say that.
Head game. Gamesmanship.
Should I go on?
Yep.
We're looking for spot zoning.
Unregistered non-dispensary. Should I keep going until we get down to the spot zoning
Sure.
piece? Procedure, amendments.
There you go.
To limit the registered dispensaries, the ordinance authorizes 2 specific named businesses to operate without requiring an application or issuance of a municipal or state license. If a new ordinance is passed, both facilities should be required to apply. Oh, yeah.
Right
See,
there,
it
yeah.
says it's advisable to limit the number of registered dispensaries.
Since Safe Alternatives operation is grandfathered, the ordinance could give priority to existing dispensaries over other applicants. If Safe Alternative converts to a full profit, the ownership structure should be reviewed.
Well, it does say right there about spot zoning.
Yeah.
Allowing a permitted use at only 2.
But the final version, they took out the names
Yeah,
to get around that.
yeah.
But
So changing to R3.
The version that was on the table when this letter was written, that was originally introduced, had the names of the businesses, but the version that was actually voted on did not have the names of the businesses. They did correct that part.
This is the law firm in Portland that wrote that up.
Rick,
I'm not sure where they're from.
isn't that Rick from across the street?
Yeah.
Well, this is Rick, but you're talking about the ordinance itself.
Right.
Came from Veril Dana.
Right.
Is that Portland?
Yeah.
I'm not sure.
Yeah.
It does talk about, purchasing remedies being several caregivers located in Caribou. The process for awarding the remaining permit should be fair for all registered caregivers operating in the city. Giving preference to one over another is discriminatory and subject to challenge.
But that ship's already sailed.
So that's effectively what we did. And
Well, see, he's saying here, selection based on first come, first served basis, which is what they put into the ordinance, was, first come, first people to apply,
There you go.
which is, yes, it's in section 4(2)C, applications will be reviewed in the order they are received by the city clerk.
So giving preference to one registered caregiver over another is discriminatory.
Right, and that's because the original the ordinance that was originally introduced had the names in there. But
Right.
the one that was actually voted on,
No name.
no names. So they did fix that, as Counselor Bagley said. Some of the, between the two versions, there were some things from this list that were corrected. And that is something that was corrected.
But, to the point, you've took their name off, but you're still giving preference to one registered caregiver over another, are you not?
Well, not if there would have been someone else who came in with their application prior to Richardson's
But
Remedies.
we
I mean,
didn't-
there's preference to the one that was already operating in Caribou, but that wasn't named. It just said, I mean, as he said, they are lawfully existing and already operating.
I don't think it meets the standard of the intent, because you want a process. What should have happened is, after we passed the law, we should have put out an announcement, have a 30-day period and solicit inputs, solicit applications for permits, and tell everybody, we've done this. The reason that Remedies was the first at the door is because they were the one that brought this in the first place, and so they were ready. It hadn't even been announced. Nobody even knew about it, so how would anybody know that permits were being up for auction? So, I think that what was done was unfair, but what's done is done. Going forward, we need to fashion this so that it's fair, and so I believe we need to write something into the ordinance that lays out that process.
Yeah.
And saying more than first come, first served will be reviewed. That
Yeah.
doesn't say it's gonna be selective. It's just,
Well, he mentions the lottery. Yeah. Yeah, I agree with you, Dan. I mean, what's done is done,
yeah.
you know, but if either business doesn't continue, then you have a process. And I like what you're kind of describing, a 30-day publicized opportunity,
Deadline,
put them
and
in,
then a lottery.
and then you draw
Yeah.
straws or whatever.
Paragraph 5 on this chapter 7 pretty much deals with it. The bottom of the first page,
The public hearing?
yeah. Yep.
Right, but that's if it stays that way. The problem was when it was passed in July, it was only passed as part of Chapter 13 and did not include the opportunity for a public hearing because staff, and by staff I mean myself, thinking that this was properly put in Chapter 7, which we've always used, and we've used for the licensing for safe alternatives, I scheduled a public hearing on his application. But then, of course, not being a lawyer, which I've stated many times this evening, I was told, well, no, that wasn't what was passed. It wasn't passed as part of our Chapter 7 licenses and permits. So he does not need to have a public hearing. It just needs to be signed off by the city clerk.
And that
Period.
direction came from whom?
Remember, it was at the meeting, remember?
No, I don't.
Okay.
But in any case, the Chapter 7, so what's done is done, like I said, but the Chapter 7 was not followed. And so our process up to this point has violated Chapter 7 as it exists today. So we still have a problem.
Well, that's why we asked North Star Planning to look at 7 and 13.
Well, we need to reconcile the two.
Mhm.
And I think going forward, looking forward, we need to make that airtight and have them consistent.
So the bottom line is, the action that the council did is legal but unethical. Is that a true statement?
Well,
I don't know that it's legal at all,
I'm not a lawyer, but as you know, I don't agree with that statement. I believe-
because it didn't follow the process. It didn't have a public hearing. It didn't, you know, and then you still get the spot zoning issue regardless of if you name the businesses. the property's the property in whatever zone they're in, right?
Well, outside the merits of the changes to the amendment, it's the process that was violated. If this had come to the planning board, as it should have, all of these things would have been discussed and resolved prior to passing. And now we're in this horrible mess because the process wasn't followed. So now we have to pick up the pieces and try to make the best of it going forward, which I think is fine. We can do that.
So if Mr. Richards were to move his operation into a zone that allowed his operation, no problem.
You mean-
Currently, we have a law that allows his operation, not true?
We do.
Yeah, it was passed.
Okay.
It's passed, but it's illegal.
It's passed, but it could be challenged, it has been challenged, so it could be overturned.
And I think the board has discussed a lot of really important points tonight and what should be incorporated and changed in this ordinance in preparation for any possible legal action or action by the city to kind of rectify anything that has been done.
And here on the chapter 13 where it says RC2, it's a no. So, Route 1, RC2, they're not allowed now?
Right.
How did this ever get so confused? It's like backwards.
So, yeah.
Everything.
So the one that was in compliance is now in the wrong zone, and the one that was out of compliance is in the right zone.
But as Counselor Bagley said, that's something that the planning board could recommend as a change to what was
Right.
passed, to just say, okay, they would be allowed in RC2 and the R3.
That's what we're gonna have to do. To comply.
As a recommendation, to make a recommendation that they, I don't know what, the way that it's the way that it is written in the one that was passed was it refers to the medical cannabis dispensary ordinance, repealing that section. And I don't know if that's what you'll have to do if you're going to repeal sections of what was passed, or if you just repeal the whole thing and maybe ask them to pass something that addresses the items that you would like to have them address in a new incarnation of this section 39.
Are you talking council or are you talking Ben?
I'm talking like the planning board, but like, we had Ben help us with this because that's a service offered by their firm,
It's
and
forte.
yeah. Planning and zoning things, is his, and since we have identified things that maybe should be amended, I don't know if you want to get together and, have maybe, and it's also the holiday season, or as I like to call it, the disruptions to the schedule. So we have people who are, have other priorities right now, which is not doing, land use tasks. So I don't know how quick we could have something done. But what are some of the things that you would want them to look at updating, maybe to bring back? I mean, the zones it's allowed in is something that we have talked about. I don't know if this is where you were going, Steve, but is your thinking that a license for a dispensary should be treated like one for a liquor license, that you would have maybe a public hearing at the planning board for your initial license, and then
City
the
council.
Yeah, city council, and then the renewals would just be an administrative approval, which is what we do for liquor now, but before we were not doing that for the dispensary. They were
Sure,
having a
if-
public hearing every year.
If that's acceptable and works.
Mhm.
Otherwise, again, city council.
Yeah,
Yeah, so initial application would be, have a public hearing, and renewals would have the overview of the fire chief, police,
Code.
code enforcement, and city manager?
well, no. The way it is with liquor licenses, it's just that that was delegated by the council
Okay.
to the chief administrative officer, which is the city manager. And again, liquor licenses, that's an all online process. Like, I do that online. I did one today.
The council doesn't approve liquor licenses?
Only the initial one.
Oh, they
Their
don't do
initial-
renewals?
They don't do the renewals. They used to. When I
Yeah,
first started
that's what I
working here,
thought.
they used to do them. But again, I think there were so many people that would procrastinate
Then
that,
you get into a time.
yeah, and you get into a time crunch and,
Anyways, I'd support that method of a public hearing initially, and a look at by multiple parties for renewals. So that was one. The other one would be adding both zones. And the other one I would like to see us add, which Dan portrays, is the lottery advertising, and then a lottery
Okay.
type selection for any subsequent new applications. I think that's fair. Anything else, people?
Now, that, just to clarify that, is that if the other entity hasn't done it within the 1 year period, or is that if there's new people that come in that year?
Well, I'm assuming that we've got two, right? And as long as we got two, we're not taking applications.
Okay, so, yeah, and that's where the 1 year, we'd
And
probably
so-
have to wait the 1 year, which is stated in here, without them having,
Oh, I see.
you see, that's stated in the licensure. So, I mean, that's,
So what if
that's
they,
easy enough to
what
do.
do they formally close up shop? There's no question, we're down to one.
Right, when, I think you gotta give them that year, and
Either
then,
Rebound or pull out.
and then that would be when you'd open it to the public hearing, or the advertisement.
The advertisement, yeah. I guess my thought was.
To be consistent with that 1 year. Basically, they're operating,
My thought was, they got done, they retired, they moved away.
well, right, that
That's
can
clear.
happen, that can happen
And
also.
then you don't have to wait a year, you know you
No,
have an opening.
If you got a formal paperwork. But
Right.
if they're not renewing it
They're
and
just-
you don't know what's the
They're
status
just
of the business.
slacking, yeah, you wait a year, yeah.
Status of the business.
wait a year, and where's that written?
It's written in, I think it's in chapter 13, but it probably should be moved to chapter 7.
Should be
I
in
wonder-
seven.
It should be in 7.
That might be a recommendation too. That makes no sense to me.
What if they could,
I think it's in,
if they relinquish their license or their operation
Right.
with a newcomer that comes along that would like to pick up their license, then they could go through the public hearing, but they should have to show their connection to the leaving operation that they would be replacing.
I think anytime there's an opening, you gotta advertise to make it fair.
Yes.
yeah.
It's not just an inside, oh, I hear you're getting done, I'm gonna put my name in. No.
So why wait a year?
I thought it was in 13.
And to let them wait a year, that doesn't hurt anything. It's just that we had.
No, but I
We'll have
can't
one
remember which one of
operation.
these it's in, but it
Right.
It does
lists,
say the term
You
of the
know.
license shall be valid for only 1 year in chapter 7 from the date of first issuance.
But that's not what he's talking about.
no, I'm talking about, there's another clause in there that,
Dormant.
right, I'm trying to find what page that was on. You remember reading it, Dave?
I think you may be referring to when it transitions out of an approved non-conforming use after a year of.
Yeah, I think that's what I'm talking about.
They have a year, after a year.
That's what I'm-
They're no longer allowed to operate.
It's
a
right here.
previously
That's what you're looking for
existing
right here?
Yeah, that's what maybe I remember the difference.
12 months.
So we don't
Yeah.
have to wait a year to advertise out that new license and get somebody.
Okay,
No,
that's
it's-
what I'm talking about, but I didn't remember what
Yeah,
section
I
it
think
was
you
in.
need to leave that.
No, absolutely.
Yeah.
Okay.
Any other recommendations, Steve?
I think if we can address what we've discussed, that's bringing us pretty close to what the goal is.
Okay. David?
I agree.
Okay. Eric?
I guess if we can iron out the non-conforming, you know, the spot zoning part of it, that's the only thing that I,
I
Well,
don't think
somebody
it is
could-
spot zoning, though,
Yeah, you're not doing it for,
because if
but it depends on like, if you're carving out something around neighbors, you know, that's where that spot zoning comes in. I'm not talking about two different ends of town, that's not what I'm talking about.
But if we're taking the R3, you know, a rural, 70 square miles of Caribou, and there's an operation at one location in the R3 zone, and that operator wants to move to another location in the R3 zone, they should be allowed to. So if you create a zone that if you were looking down at the zoning map, if you create a zone that looks like an island, that's spot zoning.
Well, that's what I'm talking about.
This doesn't do that, though.
Well, I don't know.
It's a form of the same.
I disagree with that.
In my opinion, it's a form of the same thing, because, you know, spot zoning typically is thought of, you know, you're changing the zoning to accommodate somebody who wants to operate at a use in that zone. This is kind of flipped the other way, where we're changing the use in a zone to accommodate a certain
Yeah, because
individual.
you're not changing the zone.
We're not, well,
Right.
we're changing.
The use is
zone
allowed.
Use.
in which a use is now allowed, which it previously was not. And if you go to state law, there are specific well, this is on the legal side. But that was something else we violated, because there are specific notifications and hearings that have to occur when you change the use in a zone. And so, that's buried in the subtleties and all of that. But I consider it a form of spot zoning.
See, remember when where the Chadwick Bay Ross situation, we're going all the way to Route 1. We talked about this. This is a similar situation. We're gonna call it a mixed-use zone so that we don't have the islands in the middle, you know, residential / commercial, right? But if you do carve-outs, then because that's what we all agree, like, that's the best way for that to work, going out by the motor end, right?
Oh, yeah, yeah.
Right, so, but do we want to do that for all of the rural city Caribou?
No.
See, that's why I'm worried about,
We are, in our R3 zone, there are many commercial activities that are allowed. So if you look at R1 primarily for single-family homes, R2 for multi-family homes, R3 is rural residential. Most communities would call it rural residential, but you're also allowed to do certain other types of commercial or industrial manufacturing activities, because the density is such that you're not neighbor next to neighbor. And when you work in this one particular use, what's that, Bog Road?
Yes,
Yeah.
Line Bog Road.
On the Bog Road. You know, this one activity on the Bog Road, if for some reason Caribou were to say, okay, we're gonna take that area from Dodo's around the Harris land or whatever, and we're gonna turn that into RC2, so this activity would be allowed. That's how you create a spot zone.
Yep. That's correct. That's correct.
Because I mean, there's, what, 2 mobile home parks out there? Well, one remainder, I guess.
But I still think by carving out a specific business and changing your land use allowances to accommodate that specific business, and the record shows that that's what we did, that can be challenged as spot zoning. I think that's the point Eric's making. We're carving out special treatment for a specific business. We changed where we were gonna allow these things, from RC2.
That's my point, because
expanding it to
the neighboring houses aren't gonna be, they're not gonna get changed. If you were to change it all, then that would not be spot zoning. It's just the opposite of what you said a minute ago. But if you're gonna go from Dodo's all the way down and change everybody, and you make that a mixed-use zone, that's not spot zoning.
No.
It's changing the entire zone, adding the restrictions that Rick was kind of talking about. So that-
Right, but I'm just saying, either way, it's not, I don't think it's the way to go. I mean, you know, because, you know, that's gonna complicate other things we're gonna do in the city, or we'd like to do in the, you know, in the comprehensive plan.
And I think we had looked at that section of Access Highway to go to mixed use also. I think from the bridge, maybe even back to town. I mean, it's,
At one time, that was RC2, and then
It
it got
was.
moved back to R3 because people wanted, well, there were a lot of mobile homes there, and people wanted to put more mobile homes. I'm trying to think.
It's manufactured
Yeah.
homes.
Well,
They're regulated as single family.
yeah, well, let's not get into all that complicated stuff, because at the time, I'm trying to think of how things were worded at the time, because we go through so many different incarnations of the way things are characterized in statute. But someone wanted to put, at the time, a manufactured home that was on a chassis, and they couldn't because they were not allowed in RC2 zone, only in an R3. And so they successfully got it changed so that you could put back to R3, so that mobile homes, because there are already a lot of mobile homes in that stretch. You know, it wasn't like it was not conforming to the general land use of the area, because there were a lot of mobile homes, but they just, instead of saying mobile homes will only be allowed in the RC2 zone, because that's where they wanted to put the mobile home, they just changed the zoning to R3.
I think there was a setback issue out there. When it was
I
RC2,
remember,
that you couldn't build within 100 feet of the right-of-way.
Yeah, but I think mobile homes, I don't know.
Yeah, I mean, if you're gonna change a whole bunch of properties, that's one thing. But changing one property amongst all the others for a different land use, that's where I think the problem's gonna lie, you know?
So what happens if he ceases operations and that one license is available, and now you have all R3, anybody come in and say,
Next door.
right across the street from my house? I would not like that. And nor would a lot of different other people living out in the country, peaceful, quiet, rural living. Now all of a sudden somebody has come and plopped down a marijuana dealership across the street from you, and you have to live with that day in and day out.
That's why we have a public hearing.
So we have a public hearing, that's why the planning board and the city as a whole decided many years ago not to allow these establishments in the residential zone. And now here we are, special treatment for this one business that happens to be in our purview. The intent is clear, and the record shows what the intent was, and I think it could be challenged. But it's wrong anyway. I mean, my view.
Okay.
But the council's already passed R3, right?
And there's no indication that the council will change their mind on it.
But we could make a recommendation not to. Change it back.
Absolutely, you should.
Yeah, I'd support that.
Just
Because
make a
God,
recommendation and let them do, but at least we're standing on the ground that we want to stand on.
Yes.
I mean, you can. It's, what is required is that the planning board give a recommendation
Right.
to
Doesn't have
the
to
city
be
council.
what they want us to do.
Well, and that's what we did last time.
Well, it wasn't a formal recommendation because there wasn't a public hearing. Remember,
No,
we
I-
had
I-
a couple of workshops? And I mean, that's what we were talking about, you know, before the, when there were, at city
We could have
council
remedied, we
meetings-
could have remedied that, though. Our board could have remedied that, though, if the council hadn't have done what they did. It would have taken a couple more months. But we could have,
Because you could have scheduled the public hearing and then made your recommendation.
right.
But what happened was, instead, the council voted on it and kind of
Bypass the.
bypass the planning board.
Exactly.
Because what the plan would have been is the work that was being done in the couple of workshops, get it to the point where it could go to a public hearing. You could have had a public hearing, made your recommendation to the city council, which is what's required.
Exactly.
But it didn't happen that way because before that could happen, they set their own public hearing and voted on the repeal of Section 39 and then replaced it with the new language.
So what the best we can do is to make a recommendation to the council.
Right,
Think-
after a public hearing.
Yeah.
Which is as is, scheduled for January 8th.
So, so as far as zoning, what are we going to recommend? That it not be allowed in R3? But allowed in RC2? Which would bring the other ones back into compliance.
You mean, that it would be allowed in RC2,
Yeah,
because right now it's not.
right.
Remember, now it's, if you are previously existing, you can if you were previously existing in an RC2, you may continue, but a new license wouldn't be granted for one in
Right.
RC2 if, for some reason, the one that's operating in the RC2 or the R3 ceased operations.
And I think a person that has been or has had a license issued to them to operate in the R3 zone, I think they'd have a strong case in court that they should be allowed to continue as a previously existing non-conforming
Right.
use.
Yeah, but that's different than rezoning the whole R3.
Right.
That's right.
And that's why I think if we can
So
go
that
down that
comes-
road, we're okay.
Yeah, that comes back to, let's say, the council saying, yep, we can renew your license.
Okay.
Because you
Yeah.
have had a license in the past as a currently previously existing non-conforming.
So that would allow the council to do what they wanted to do, and
Without opening it
yet,
up for more.
right, keeps us on solid ground for the future.
So it's like to fix the RC2, to bring that back into a allowed use
Right,
with the planning board approval.
right. Everybody okay with that?
Yes, sirree.
Are you making the notes, Aaron? I have to go because I have got to get to Walgreens before they
Go.
Because my doctor has phones.
Thank you for your time.
Thank you,
It's
Ben.
been
Yeah, I'm
very,
sorry.
very helpful
But,
tonight.
Pharmacy still open?
It stays open till 8, and so it's 7:45.
Go.
And I know that they have it because I got his text that they're working. He's called me and told me they're open till 8, so get there before.
All right. Anything else
so much.
regarding this matter?
No.
Okay, then I think we're done. All set, Eric?
Do we need to make a move to adjourn?
I don't know, I never called a meeting.
I don't think we're in a real
But I can.
meeting, but whatever.
By consensus.
Thank you.
No, my big concern was, okay,